Good afternoon. I am so happy to be here with Travis Hall. Travis, if you could take a moment just to introduce yourself to our members and tell us what your title is and where you work and what that organization is.
Sure, absolutely. So, hi, I'm Travis. I am currently the acting deputy associate administrator for our Office of Policy Analysis and Development at the National Telecommunication Information Administration, which is quite the mouthful. Peeling that onion back, I am currently helping to lead our internet policy portfolio within NTIA, within the Department of Commerce. And what NTIA is, most of you probably know us more for our work on broadband and the Internet for All, or on our role in managing the spectrum. But perhaps your members know us from our role as the President's principal advisor for telecommunication information issues, including privacy, right? So we cover a range of issues on the Internet policy side, from cybersecurity, some of the national security portfolio, like we do a lot of work within the interagency on that. Some copyright work, basically anything that touches on telecommunications and information. And so where I come into this picture is I started 7.5 years ago, primarily focusing in on privacy. I have a background in privacy as an academic prior to this job. But have since come to, in terms of helping to lead our policy shop, cover the range of policy issues. But my area of expertise, my area of love, is still privacy, and fortunately, it is something that I still get to work fairly closely on. So our office, in terms of where we sit, we are advisors, right? We're not the FTC, we don't regulate. We're not the White House, right? We don't set policies for the administration, but we help to advise what those policies are. We help to advise the regulators, such as in our comments to the FTC's Commercial Surveillance and Data Security ANPRM, and we put out reports. One of which, the most well-known, was led to the Consumer Privacy Bill of Rights under the Obama administration, and we were key players in the drafting of that and the draft legislation there. So we continue to play something of a similar role, particularly on consumer privacy within this administration as well.
Thank you so much for that great introduction to you and to NTIA. The subject that brings us together today is your current request for comment on privacy, equity, and civil rights. And wondered if you could begin by telling us a little bit about this process. We understand it began with 3 listening sessions convened back in 2021 on this. So when you launched these listening sessions and requests for comments, NTIA said these consultations would inform a report on whether and how commercial data practices can lead to disparate impacts and outcomes for marginalized and disadvantaged communities. So can you tell us more about who is the audience for this report and what does NTIA hope it will achieve?
Absolutely. And so taking it back a step first, just talking process, we were asked in the beginning of the Biden administration, what should we do about privacy? And, our kind of initial answer was, well, you should pass privacy legislation. And they said, well, we agree with that, but we're not ready to quite go there yet. At this point in time, the tech accountability principles have come out that Joe Biden has called for privacy reform, federal privacy reform in his State of the Union address, so we can say that loud and clear. But in the beginning of the administration, they wanted to figure some things out first. So they said, well, it's not quite that. What else can we do? Where can we drill down? And our recommendation was to start this work stream on a focus on equity and civil rights. And there was a couple of different reasons that we took on that particular tact on talking about privacy. The first is that it is an area that really it's where the rubber hits the road, right, in terms of a lot of the harms, right? Privacy is, infamous for being a little bit of a conversation around what are the harms. The harms tend to feel somewhat abstract. They tend to feel somewhat nebulous and not actualizable. But that's not necessarily true for a lot of marginalized communities, right? A lot of things where, small marginal costs for folks who are more privileged end up being actually significantly greater, right? Like the loss of a credit card or the loss of the shoe leather cost that it takes to recover from identity theft. Or conversely, that your position inside of larger systems, where you are on probation or in terms of childcare, or in that kind of system as well, where the revealing of information or the collection of information can potentially lead to significantly greater impacts than it would otherwise. And there's also, just simply, folks who are LGBTQ, where the simple collection of particular forms of information can be complicated and can be difficult. Whether how you say what your gender is on a form, right, and whether that those options are actually fit what you say, who you are, where that itself can lead to potential impacts. And so that was one thing. We actually see that as an area where these abstract harms are actually realized and can be, where in focusing on that and in trying to raise up and mitigate those harms, we would actually be mitigating the harms that for others are abstract, but are no less, are potentially real as well, right? By focusing on where the rubber hits the road, you can increase the privacy protections and mitigate the harm for everyone. The second is that, the conversation around privacy domestically, it's at a little bit of a logjam, right? It continues to be at a little bit of a logjam. And so we were hoping to help invigorate that conversation by bringing in new voices, by bringing in folks who perhaps were not as central in those conversations, folks who are from marginalized communities, folks who are, traditional civil rights organizations, others, to come in and to bring their focus to bear that might help, move the ball forward a little bit in ways that hadn't before. And then finally, but for my part, I thought it was a really good story that industry could tell as well, right? Where industry does not want to discriminate, can say these are the things that we are doing in order to mitigate these impacts. And by focusing on real actualizable harm on real communities, you can break through some of that logjam of concern about some of the more abstract stuff and actually try to mitigate real harm. And that is a great story for industry to tell in terms of the actions that it's taking and the policies that it's supporting. So that's a little bit of the background where this is all going to. We are still planning on putting out a report. Unfortunately, originally the plan was to put out the request for comment immediately following the listening sessions, but bureaucracy happens, and so we came out with it in January, and we are still planning to take the inputs from both the listening sessions and from the request for comment, turn it into a report. The audience is policymakers, but also the policy community, I would say, right? We want to engage with both in the request for comment, but then also in terms of our recommendations, our thoughts, with the policymaking community from industry, civil society, academics, and others, in order to, again, move the ball forward in terms of both passing federal privacy reform, but also just simply other actions that could be taken in order to help mitigate some of the risks that come from necessary commercial data flows.
Super. And you've already anticipated a number of questions that we had, and we know our members have, about how this relates to ongoing efforts at federal privacy legislation, FTC action. Were there specific findings that came out of the listening sessions or questions that came out of those sessions that you said, boy, there are some things we really wanted to learn more about? I mean, the request for comment has some very detailed and very interesting questions, but are there any key themes emerging from the listening sessions that you might point our members to?
Well, so I think that some of the takeaways that I would say from the listening sessions, one, I do think that we are starting to build a record of, and I think that the FTC, ANPRM, and some of their questions as well are starting to build a record around solidifying an understanding of what disparate impacts occur, where the harms actually lie, and what some of the problems are. One of the things that I would note from the listening sessions is that the focus was not just simply on privacy law, right? There was also quite a bit of conversation around civil rights law and where civil rights law and its enforcement needs to be updated and improved. And I think that, with this administration in particular, there is a focus on that at the EEOC, at the CFPB, at labor and elsewhere, on thinking through these issues. But I do think that this is, I would say that that's a more recent development. And, certainly when we started this process, that was not necessarily the case. And so, so I do think that that one of the things was, and not just simply looking at, I think our, from our writ, right? We're not civil rights experts, right? We are not the agencies that are charged with that. We are, we're much more focused on privacy and privacy legislation. But I do think that one of the outcomes of this is potentially a reexamination of some of the civil rights law and some of the other types of government actions that are focused on flows of commercial information, and thinking through the basic principles and the spirit of both of these laws and what they're trying to accomplish and whether they are actually up to the task right now with our current information ecosystem.
I think you've already kind of pointed at it. The request for comment mentions a few specific services like online dating apps, streaming services, online gaming community. I don't know, not trying to pick on any services, but I wondered if you wanted to highlight any specific areas of potential concern around those, or some high level concerns that run across them.
I don't think that, I think that we use those as examples. I truly don't, we are the Department of Commerce. We're a part of the Department of Commerce. We are not in the business of pointing fingers at particular industries or necessarily particular actors. Some of whom, there are some bad actors out there, but that's typically not our business. But those were, for the most part, illustrative. And I would say that one thing that to the last question, but then also to this as well, is that there is quite a bit of overlap with conversations around artificial intelligence. One thing in particular that I do think is important about our process that's different than, say, for example, the Blueprint for an AI Bill of Rights or the NIST AI Risk Management Framework, is that that is only part of that conversation, right? And that there are harms that can come from the collection and storage of data and sharing of data that is unrelated to decision making, be it automated or not. And I do think that there needs to be some consideration within context of those types of risks, particularly again for marginalized and disadvantaged communities. And so, some of the things that were highlighted, right, like online dating services, why is that important? Well, because there is a particular vulnerability that can come from that particular context of, again, people putting out information that indicates that they are a part of a protected class, putting out information that is, in context, quite vulnerable, right? Like you in order to date, you got to be a little bit vulnerable and you got to share a little bit of yourself, and you share a little bit of yourself in ways that is intended for a particular audience and not for everybody else, right? And so, and that's again where there's particularized harm to marginalized communities, but there's also it kind of like is just simply where there's most traction for the abstract harm that can occur for everyone. So again, not to single out online dating, but it's just simply as illustrating where where information flows, when taken out of context, when used improperly, when misused, or used carelessly, right? Can cause harm to the individuals who are the subjects of that, who provided the information, or didn't know that they were providing particular information, and care needs to be taken to ensure that harm does not occur.
It's really helpful, and our time is rapidly drawing to a close. But before we go, one thing at CIPL we pride ourselves on is a global perspective, trying to learn, see if there are best practices, lessons to learn, challenges to compare from around the world. Wondered if, as you explore these topics, you're looking at any international comparators or perspectives on these issues.
So absolutely. I mean, I would, I would say that in terms of privacy law, certainly we are constantly looking at and thinking through other models, and there are other models now to compare to. There, GDPR has been in place for going on 5 years at this point in time, so there are ways to look at what works and what doesn't work. The EU AI Act, right, is potentially going to be passed, and that is another model. The DSA has passed, and that is another model about of trying to not focused on personal data, but to mitigate harm. And then there are other laws, of course, internationally as well, that are thinking through and grappling with these issues. I do think, and let me be a little bit patriotic here. America has been a pioneer in terms of, laws such as the ADA, the Americans with Disabilities Act, in terms of some of our civil rights laws and protections, in providing protections for the most vulnerable among us. And of course, all of those are hard-fought political wins, right? From decades of activism and hard work, and these things should not be taken for granted. But I do think that we as a country have been forced to grapple with these issues, and to have, particularly again with ADA, I think that we can hold our heads high in terms of the protections that it provides relative to other countries. And so I do think that similarly, our focus here, and this administration's focus on equity and civil rights overall, I do think this helps us stand apart. I have not, at least personally, seen that as a major focus in other countries, and I'm hopeful that we can continue to be at the cutting edge and provide leadership on that. I mean, of course, we as a country struggle with some of these issues, but other countries do as well. And I do think that we at least are attempting to grapple with that a bit more head on.
Great note for us to conclude on. Thank you so much for your time, Travis. Really grateful.
Okay, thank you.